Hello, cryptocurrency investors. There has been a big win for Ripple in the court in California. The case Coffey versus Ripple, that case is going to federal court 8/10/2018. The other part of this program is called Ripple Suits Should Be Dismissed, a non-lawyer and XRP investors' take on the lawsuits against Ripple. So I am going to get into a little bit about the case proceedings. First, I need to say a few things. Hello, XRP investors, friends, detractors, enemies, those involved in the success of Ripple and XRP. My name is Reggie Mabry, and I have from life experiences some peculiar knowledge of complaints and dismissals. First of all, I am not a financial advisor. Anything that I say should not be construed as financial advice. It is for informative and educational purposes. I am not telling you to buy, sell, hold any crypto asset, including XRP. I also am not a lawyer, nor am I giving any legal advice. I'm giving you my opinion only about what I perceive, or in this case, suits entered in bad faith against the crypto asset XRP and company Ripple. I own some XRP. I did not buy it as a security. I purchased it as a special asset. I purchased it as a utility token to use in the future, as one purchases a piece of art that may, sorry, not my, but may increase in value. In this case, I purchased a wonderful piece of the future, of future technology that I hope to use in ways that right now I can't completely perceive all of its usages at this particular time. So let's get into what happened in the court in California on August 10, 2018. There has been movement on the case Coffey versus Ripple Labs Incorporated at all. This was one of the first class action filings against Ripple Labs for unregistered securities, and there is some important movement on the case. Let's look at it really quickly. Friday, August 10th, 2018, order by Judge Phyllis J. Hamilton denying 16 motion to remand. That should be a motion by the plaintiff to keep it where it is. On Thursday, the day August 9th, the day before, notice by Bradley Garlinghouse, Ripple Labs Incorporated, XRP2 LLC, notice of pendency of other actions or proceedings pursuant to Civil Local Rules 13-3. A motion to relate cases filed by Bradley Garlinghouse, Ripple Labs. So it seems to some motions earlier to relate the cases, maybe possibly combine cases. I'm not so sure. I did not read the motion from Pacer. And so from this week, there has been some big movement. You see, beginning August 1st, a proceeding held in front of the judge. Tuesday, August 7th, transcript order. Wednesday, another transcript order. And then finally, the actual denial of the 16 motion to remand. Now, let's see if I could just take a look at this. I searched Scribd, and this is where you can find it. This is the Coffey versus Ripple 8/10/18 motion to remand denial, and then basically this is the order, and this was brought by plaintiff Ryan Coffey against defendants Ripple Labs, and plaintiff filed this action in San Francisco Superior Court On June 1st, 2018, defendants removed this action pursuant to the Class Action Fairness Act, CAFA, under 28 U.S.C. Section 1453, removal of class actions. This is plaintiff motion to remand came on a hearing before this court on August 1st, 2018. Plaintiff appeared through his counsel, and so basically at the end of the day, this is a short win for Ripple. In conclusion, in sum, when an anti-removal provision such as Section 22A is invoked, the threshold question is whether removal is being evaluated by way of the general removal statute 28 U.S.C. Section 1441A, or by way of a separate removal provision that grants additional removal jurisdiction in a class of cases which would not otherwise be removed under the prior grant of authority. If removal is being effectuated through a provision like Section 1453, that confers additional removal jurisdiction, and that provision contains no exception for non-removal federal claims. The provision should be given full effect. So and then it says down here, Section 1453 grants defendants, in this case Ripple Labs, XRP 2 LLC, in addition, independent basis for removing an action from state to federal court. The parties do not dispute, and the court finds that plaintiff's California claims satisfy CAFA's removal requirements because Section 1453 says nothing about incorporating Section 1441A's except clause or otherwise deferring to anti-removal provisions. Section 22A does not bar removal of this action. In addition, plaintiff's application of Section 22A to all removal provisions unnecessarily renders numerous statute clauses superfluously. Lastly, removal in this situation accords with Congress' overall intent to strongly favor the exercise of federal diversity jurisdiction over class actions with interstate ramifications. Jordan. So this looks like this case from Coffey is now headed to federal court. And when it goes to federal court, Ripple will most likely issue a 12B6 motion to dismiss for failure to state a claim. Now, I may talk about that a little bit more. I'm a non-lawyer, but I have been in federal court on this particular matter. So I representing myself, and I'm going to tell you that this looks like this class action is on its way to federal court. And it looks like there's going to be a 12B6 motion to dismiss failure to state a claim on something called Twombly-Iqbal, the dreaded Twombly-Iqbal. So this is exciting. So I wanted to let you know, and I'm thinking about maybe doing another quick PowerPoint. So now the second part of this presentation is my personal opinion about what is going to happen in this particular case, and the way it's looking is going exactly the way that I'm saying, and then I think that all parties know on the legal front what is probably going to happen. Team that Ripple has put in place. They're very sophisticated attorneys, legal team, advisors, and I'm pretty clear that the case is going to go to federal court, and there's going to be a particular motion that is going to be served. So before I say that, look, just telling you about myself and probably about many of you, even though I can't speak for all of you. But I believe when I was purchasing this crypto asset, XRP, that the price would go up and increase in value. However, I knew when I purchased any asset or purchasing any asset that the same asset may decrease in value or be worth in the future nothing at all. I think that's clear for most of us who acted in good faith. Now, I cannot speak for any other purchaser of this crypto asset XRP, but at the time of purchase, um, I purchased this asset not from the company Ripple, but on an exchange of similar assets called cryptocurrencies. If there is something called similar, most of the tokens are not utility tokens, but they are on this exchange, and this is the only way that I knew that I could actually purchase it. Now, I believe that the majority of the people, including the people involved in this suit, purchased it the same way from a party not affiliated from Ripple Labs. I believe that the plaintiffs are being disingenuous because XRP may have been on an ICO for a stage, but then moved into the exchange markets. So it was not on a continuous ICO as the plaintiffs say. So I believe that what they are saying is disingenuous. I do not believe, and I believe that it's untrue, that the plaintiffs purchased XRP any other way but like the rest of us on a exchange. If they purchased it on a exchange, they knew that these exchanges were speculative. XRP was not in a production stage, and so the speculative market could dictate the price, and so there is no real technical analysis, or the technical analysis that you will look at cryptocurrencies would be different than it would be for a security. It would be highly speculative. So I think that the plaintiffs, again, are being disingenuous. Now, it is my belief that those who are attempting to sue Ripple Incorporated entered into the litigation to harm Ripple and XRP for bad faith reasons. If any of these people who are suing Ripple holds any other crypto asset that was ICO'd, then straight away that is a bad faith. This is a bad faith suit because they are targeting XRP. So any of these people who are suing, Coffey and the others, these plaintiffs, if any of them owns any other crypto that was at some point ICO'd, then to me they lose a huge part of their argument, because then they have to explain why they are targeting XRP for losses and not any of these other coins. Now, I am doing this presentation to inform those who purchased the crypto asset XRP as to why I think these suits against Ripple will fail to state a claim in which relief can be granted in federal court. Now, I am not employed by Ripple, paid by Ripple, and the only contact I ever had with Ripple was to attend a fintech meeting. I attempted to interview Ryan Zygone, but he promptly told me that he could not talk to me directly and that I should write Ripple, the company, for a proper interview. I ended up asking an open-ended question to the panelists, and Ryan Zygone, as well as others, responded to that question without any regards to me personally, but to the question itself. This is noted in a video with the French fintech, and you can find it on Bank XRP. You can find this video, and that is my interaction. When I found out that Ripple was having a office on 23rd Street, I live in New York, so I went down there. But at the time that I went down there, the office wasn't open, and so what I'm saying is I have had no professional contact with Ripple Labs, and I'm just stating for the record my relationship. Now, to understand why I think this case will be dismissed is that the lead case against Ripple has presented its cases against Ripple with labels and conclusions that are not accurate. And as I say this, I have to say this again. I'm not telling you to buy, Ripple, sell if you own it, or even to blog about it. The purpose is simply to inform you of the laws as I see it as a non-lawyer, as a citizen of the United States, who in my case, my ancestors were brought here forcibly into the United States under both the legal and illegal slave trade. In the experiences of my family, we are like others who are simply trying to forge ahead and use the future and the technology for our pursuit of happiness. I've always been interested in federal cases and state cases and law, though my career only had me work in a law office, and then I ultimately had an issue. But the fact of the matter is, my status in the United States is based on some federal and state law. So I've had this interest, but let me get back to this. Essentially, the lawsuits against Ripple is that they are selling an unregistered security to the public for the gain of the company and its executives and its insiders. That's basically what this suit is about. At the date of the writing this video blog, the Security Exchange, the SEC, has not rendered a decision if XRP, the token, is a security, or even if it was at one point, it's still a security. So that's going to be a major issue going forward, because the people who have made this claim, if you read their case, they acting as if they are making a decision for the Securities Exchange Commission whether or not this token is a security, and the Securities Exchange Commission has not spoken yet. So to me, that is a label and a conclusion, and it will fail to state a claim, and I think that they know it, and I'm certainly sure that Ripple and their team knows it. So any of these labels and conclusions that this suit has, when it's going to be pushed into federal court, is going to fail to state a claim. At some point, Ripple also became a subject of an enforcement action by FinCEN, and to my knowledge was allowed to continue to sell the asset as long as it fulfills its enforcement agreement. To the best of my knowledge, I believe that it has, but this is only to the best of my own knowledge. But when I looked at the Coffey versus Ripple suit, I did not see too much about anything about the FinCEN agreement as to why the XRP itself could still be sold. And I think that the failure to include that will make their points conclusory. It's like who they're trying to fool, right? I think they entered it into state court because they thought that state court had some type of heightened jurisdiction than federal court, which sometimes federal and state statutes kind of run parallel. Sometimes in state and city statutes, they do have some type of heightened rights. You know, they always say that the federal decisions are the floor on which no rights can fall below, and city and states statutes are the ceiling which all rights and can rise to. I think that the Coffey and others were trying to put it into state court because they felt that the state court has some, how can I say, some more strength than federal court. But the issue is the federal court at the time of this case has not decided if Ripple is a security or not. So, and then there is a FinCEN agreement that's solely within federal court that should be discussed in federal court. And so this case will have to move out of state court. So that's why it's a big win. But now, there was a matter of the Securities Exchange Commission versus Bronson. Was cited as a legal standard in that case to help decide if the defendant could dismiss a claim against the Securities Exchange Commission using the 12b6 motion to dismiss. In the case of Securities Exchange versus Bronson, the defendant was not successful for its motion to dismiss was rejected. For the pleadings of the Securities Exchange Commission was sufficient to stand against the heightened pleading standard of Twombly-Iqbal. Now, in this case, Ripple is the defendant and Coffey is the plaintiff. Ripple will most likely present a motion to dismiss on failure to state a claim, and Coffey will have to defend on that. And so there are a number of cases that talk about something called the Twombly-Iqbal. And Twombly-Iqbal is a kind of combined thinking on two cases that ultimately became what you call Twombly-Iqbal, which requires a heightened pleading standard for those engaging in a suit, meaning the plaintiffs. And if it fails, then the suit can be dismissed by the defendant. And so if the case presented by Coffey fails to have a higher fails in this heightened pleading standard, it will be dismissed. And the reason why these suits are often dismissed is because they are conclusory and they are labels and there are facts that are inaccurate, and that will carry through, causing the whole suit to be dismissed. So in the matter of Securities and Exchange versus Bronson, the Securities and Exchange Commission itself was the plaintiff, and this suit was a motion was brought by Bronson to the Securities and Exchange Commission, and the Bronson motion failed. So you have to look at the Twombly-Iqbal 12b6 motion to dismiss both ways. You have to look at when it fails and when it succeeds. Now, in looking at the first lawsuit, this Coffey suit, I believe that Ripple should move all cases to federal court and then move to dismiss those cases with 12b6 motion to dismiss failure to state a claim. Because I don't think this suit can withstand the heightened pleading standards or to survive a motion to dismiss. And so what I expect is that when it goes into federal court, Ripple will combine all of the cases against it into one case, and then begin dismissal, or it could dismiss. It could seek to dismiss the Coffey suit first, but I think once it's in federal court, I think that judges will combine the cases for in the interest of justice and time. They will combine the cases, and then it will be just one case. But the Coffey case was the first case, and I think that is terribly weak. Now, let's look at this case, Jones versus Allstate Insurance Company, and this was rendered June 19th, 2017. And let's look at the issues on what I'm talking about, a motion to dismiss. Now, if the case finds its way in federal court, then I believe that Ripple will issue a 12b6 motion to dismiss. Now, for Coffey to survive a motion to dismiss under Rule 12b6, a complaint must provide more than labels and conclusions, or a formulaic recitation of the elements of cause of action. Bell Atlantic Corp. versus Twombly, citation, admitted factual allegations must be enough to raise a right to relief above the speculative level on the assumption that all the allegations in the complaint are true, even if doubtful in fact. While a complaint need not include detailed facts, it must provide more than unadored the defendant unlawfully harmed me accusation. That was in Ashcroft versus Iqbal. Now, so these things that Coffey has said, that Ripple tried to bribe Coinbase, that XRP is a security, some of those are labels and conclusions, and some of those are even doubtful. And then if they are not all true, then that is going to make the Coffey suit fail to state a claim. Now, Twombly-Iqbal requires that the court to take 3 steps to determine whether the second amended complaint will survive. In this case, it was a second amended complaint. Defendant's motion to dismiss, and those are the cases. First, it must take note of the elements the plaintiff must plead to state a claim. First, it must take note of the elements the plaintiff must plead to state a claim. Next, it must identify the allegations that are no more than legal conclusions and thus entitled to the assumption of truth. In the Coffey suit, that would be problematic. Finally, where the complaint includes well-pleaded factual allegations, court added, assume that the veracity and then determine whether the plausibility give rise to an entitlement to relief. Now, so those are the 3 steps that this Coffey suit will have to go through, keeping in mind that there are some issues, like I have said earlier. If Coffey owns any other cryptocurrency besides Ripple that went through an ICO, then that would be an issue. Why target Ripple and why not target all of these, or why not target the governing body that allowed this to for them to be sold? This other thing about Ripple bribing Coinbase and other exchanges, that's going to be very problematic. The mere conclusion that Ripple is a security and not a special asset is going to be an issue because the Securities Exchange Commission hasn't decided. The other thing is the defense and enforcement. Now, this presumption of truth attaches only to those allegations for which there is sufficient factual matter to render them plausible on their face. Conclusory assertions of facts and legal conclusions are not entitled to the same presumption. This plausibility determines is a context-specific task that requires the reviewing court to draw on its judicial experience and common sense. So, in the case of Coffey versus Ripple, the issue is that if you read it, they are making conclusions as if some court has already decided that Ripple was selling illegal securities, in the sense that XRP is a security. And even if it was a security at one time, at the point where Coffey purchased it, was it then something else? And so I did another program on talking about some guidelines of the Securities Exchange Commission, talking about whether if something was a security at one time and then at another time something else, and some special guidelines as the Securities Exchange Commission is looking into and deciding whether things are securities or not. But at the same time, XRP has not been decided to be a security at the time of this suit. So that would be, I think that this is, if there was going to be a suit, it would have been better after the Securities Exchange Commission makes a decision or a finding. This is way before that happens, and so it becomes conclusory. Now I was going to first examine this complaint, Coffey, from my eyes, but I am 100% sure, 1,000% sure that Ripple has some of the best legal support and experts. So I will leave it to them to as I just wanted to kind of point out some issues about or what I feel is about to happen. I will end this presentation by saying that the Securities Exchange Commission again has not decided that XRP is a security, and even if it was, it may not be at this time, and certainly not at the time of the purchasing of XRP by the plaintiffs or at the time of the suits. Ripple, the company, in my opinion, simply through its software provides a usage case for this token, and that this usage case will make the token, if not increase in value, change how the world transmits money. I see Ripple as the fictional Starfleet of Star Trek, all rights included to the owners. I'm just using their names as to make a point. So I see Ripple as Starfleet, and XRP as the dilithium crystal that allows Starfleet ships to enter into warp speed and having an advantage against its enemies in its new frontier. It's funny, ironically, dilithium can be abbreviated as DLT, and here art imitates life. XRP is a DLT, and it is going to fuel money transmissions for the world in the future. So the plaintiff's determination as to Ripple being a security and his accusations are simple labels and conclusions. So it is my hope that the defendants in their suits or enter into some settlement or some settlements reached for their minor losses, and let us boldly go as no civilization has gone before, borrowing again from Star Trek series with the DLT called XRP. However, if XRP is found a security, then let the company Ripple do an IPO and give its purchasers the right to own shares or keep their XRP as a token. So this is the end of my presentation. I've been Reggie Mabry. This is, again, a big, big win for Ripple. And the other part of it is that Ripple suits should be dismissed. This was my non-lawyers and XRP investor owner take on the lawsuits against Ripple. Happy investing. Have a great day.